My name is Paige Lohuis, and I am the Marketing and Events Manager for sFOX, and today we will be breaking down the collapse of Prime Trust and how to safeguard your assets moving forward. John and Daniel, it's great to have you here. Can you each tell us a little bit about your role here at sFOX?
Sure. I'm happy to kick us off. My name is John Mannino. I am the Chief Compliance Officer here at sFOX. I'm responsible for all things on a compliance level basis. I'm just about to hit my 2-year mark here at sFOX, and I come from a TradFi world where I spent many years dealing in operations and compliance, specifically around OTC margin and collateral aspects, and kind of in a post sort of Dodd-Frank world, how we manage all that things. So happy to be here today.
Thank you, Paige, and good to be up here with you, John. Yeah, my name is Daniel Hinton. I am head of the finance and operations teams here at sFOX. Been with the company about 5 years. My background was in investment banking and law, and obviously handle all the finance and operations side of things here.
Great. So the collapse of Prime Trust has many concerned about the future of secure custody solutions in the crypto sector. For this session, we're going to cover the top questions everyone has regarding Prime Trust and understand what this news means for the future of digital asset management. We want to remind everyone that we will have time for questions from the audience towards the end, so please feel free to submit any questions you might have in the Q&A box below, and we'll do our best to get them answered today. Righty, so on June 21st, Prime Trust was ordered to halt operations while its regulator looks to take over. Daniel, can you explain who Prime Trust is and who their clientele is?
Sure, yeah. So, Paige, Prime Trust is a fairly well-known name in the crypto industry. They did so they're a qualified custodian in the industry. They kind of branded themselves as a fintech API solution. So their typical client would be a business operating in the digital asset space that needed easy access to a suite of APIs. Those were custody, trading, security related types of things. But it was almost exclusively business clients across exchanges, fintechs, and other similar types of entities. They also had a decent footprint in helping more global businesses get exposure in the US. Right, so helping launch exchange services in the U.S. Through their trust company.
Great. John, what happened that caused this crypto custodian to be in this situation?
Yeah, so it's a
pretty question.
Pretty crazy sort of situation, as it tends to be with many of these. But I want to pull up a few slides actually, because we're going to do a little bit of a whistle-stop tour here. We're going to kind of go through sort of the Prime Trust timeline here over sort of the past sort of few years, everybody, and level set everyone to this. So hop aboard. We're about ready to take off here. So 2017, right? Prime Trust, it becomes a retail trust company in the beginning of 2017. It's licensed in 15 states as a money transmitter, and it provides trust services and operates in the fintech space. Its business model to consumer, right? So this is a little bit kind of what just Daniel was just sort of alluding to, right? So that's 2017, right? That's when they start. So 2018, right? They engage in the business of holding crypto in trust for clients. It's the same, Prime created their digital wallet for the purposes of holding digital currency in its trust for its customers, right? So 2018, this is kind of really when they start their true sort of custodial services. 2019, right? They hire they contract with Fireblocks, which is a digital asset security platform that I think many in the industry are well aware of, to store their cryptocurrency in custody, right? And through a migration from their wallet to the Fireblocks platform, this was kind of completed, in 2020. The original wallet continues to exist, but it was marked as inactive, right? So this is, an important point here that is just as an important part of the timeline here. So next slide, 2020, after the migration happens, Fireblocks, Fireblocks is completed, right? Here's a really important fact, right? Prime comes under brand new management, right? And when the brand new management comes in, they're purportedly informed that by the prior management that all crypto assets were maintained and accessible in the Fireblocks platform, right? That's what the new management team was sort of told at this point in time, right? January 2021, right? Prime, reintroduces specific legacy wallets, and it's understood that Prime did this because there were limitations associated with creating new wallets on the Fireblocks platform. What those limitations are, it's a little bit unclear from sort of all the filings, but Prime purportedly believed that the legacy wallets that were previously on the Fireblocks platform were configured to forward to the wallets accessible on the Fireblocks platform. However, at the end of the year in 2021, and here's another important point, right? It discovers that it's unable to access its legacy wallets, and then the crypto that is contained in those wallets, right? So big problem number one for the management here, right? So it then, it starts and into March of 2022, to basically to satisfy withdrawals from the inaccessible legacy wallets, right? Huge no-no, right? Prime begins to purchase additional using customer money from its omnibus customer accounts. Huge problem here, right? With that, right? Prime is then reported to have been making efforts to regain access to their legacy wallets. However, as of right now, right, through the date of this the petition, right, they still can't access those legacy wallets, right? And in addition to the above, it's been reported that, as the frequency of customer withdrawals increased, they were no longer able to kind of, meet these withdrawals. And so again, as of June 26th, it basically became understood that it owes somewhere in the neighborhood of $85 million in fiat, and further another 2 million in crypto. That's kind of, so it basically just becomes a situation where right now they can't meet any of their customer withdrawals, right? So that's kind of what, around kind of what ended up happening and why we're in the spot that we're in today. Right. Here's, June 21, right? Prime Trust regretfully informs its clients that it was halting deposits, by order of the Nevada Financial Institution Division, or the NFID. And then on June 27th, right, the NFID announces that it's petitioned the Court of Nevada to put Prime Trust into receivership. Really only because they have about 3% of the customers' cash on hand. So huge problem here for Prime Trust and its customers.
That's great, John. Thank you for that. What does it mean to be in a receivership? Is it the same as being in a bankruptcy?
Yeah, so this is also a very important point that I want to just kind of highlight a little bit on, right? There's a lot of confusion sort of around this, and I think it's very common that there's confusion around these terms of bankruptcy and receivership, but they're really sort of fundamentally different, right? So bankruptcy is really sort of this whole process of kind of neither reorganization or unwinding of an organization. And so while is really, aimed at like shielding the borrower and not necessarily the lender, this is not what's happening in the prime trust situation, right? So they're in a receivership. And so really a receivership is, again, slightly different in the sense that it's not really a legal action. It's really sort of an adjunct solution. It's kind of what it's referred to, right? And so really what this means is, the receivership is the court appoints a court appointed, receiver who's meant to sort of, oversee all of the assets that are kind of in this troubled company right now. And initially the goal is to really just sort of help the company manage through this really sort of a difficult time, with the hopes of kind of coming out on the other side with the ability to, still be in business. Again, the goal of the receivership is generally to turn companies to profitability and to avoid bankruptcy. Like that's generally sort of what we sort of see in this space, right? An independent receiver is usually appointed, right? They manage all aspects of it, but it's really important that they are viewed as, an independent receiver and as part of this whole process, right? The company can then kind of go through sort of, a restructuring component, while it's sort of under the space, or, right, it could basically be like, what, this is too much of a mess. There's too many problems. We actually need to kind of move towards a bankruptcy. So there's a couple different outcomes that could really kind of come from this, that, we are expecting to sort of see. I think one of the challenges here, specifically in prime trust, is, are they going to be able to access the crypto that was sort of held in sort of these wallets previously, and are they going to be able to kind of continue to meet sort of, would they still be able to meet client demands? Now, again, the Nevada FID kind of halted all deposits and withdrawals as they begin to sort of sort out this whole kind of mess that they're in. But it is, there is a process that's in place around kind of, trying to kind of manage through this process. I do want to say, right, because receivership and bankruptcy are kind of not the same, but they're not necessarily mutually exclusive, right? And so the same, as I was saying, right, is that the receivership could end up moving in towards, declaring bankruptcy at some point in time. I do want to kind of just sort of, highlight that, in the press release that sort of went out from the Nevada Financial Institution Division, it says the petition, asked the court to appoint a receiver to take over the day-to-day operations of the company and thoroughly examine all of its finances to determine the best option to protect Prime's clients, either by rehabilitating and returning the company to private management or by liquidating the company, right? So clearly in the press release that the Nevada Division of Banking has stated is that, either one of these are options that, the receiver has at its disposal to kind of manage through this whole process, right? So hopefully that kind of explains a little bit of the differences between receivership and bankruptcy. But right now, Prime Trust is still within this receivership.
Got it. Going off of that, each state has a different formality in order to have an approved trust license. Prime Trust was regulated by the Nevada Division of Financial Institutions, and sFOX's safe custody is regulated by the Wyoming Division of Banking. Daniel, can you tell me how the Wyoming public trust companies differ from Nevada trust companies with regard to a process like this?
Sure, Paige. Yeah, I'll be happy to walk through a few of these considerations. Just for starters, when you're thinking about setting up a trust company, you have to choose a particular state to do that in. There's the Dakotas are popular, Nevada is popular, New York is popular, and obviously Wyoming is very popular too. Wyoming in particular has an interesting history with business organizations. You know, they were the first state to initiate the concept of an LLC back in the 80s, right? So they've for many decades now, they've been a leader in, you know, and honestly, the LLC was a very revolutionary concept when it came about, sort of as a middle ground between a personal partnership and a formal C corp. More recently, though, they have been coming out with some really great legislation around stablecoins. So they're trying to create the first state-based stablecoin. They have a DAO program where if you run a DAO, you can kind of have a hybrid LLC that's a DAO that can manage the operations there. So in our opinion, they're really the only state with a comprehensive legal framework specifically designed for digital assets, and they've passed about 24 laws that are specifically addressed to digital assets. Outside of those regulatory considerations, you know, Wyoming is a great place to be, and I think everybody enjoys being there. They have some really fantastic tax benefits as well. You know, no state income tax, no capital gains tax. They have very favorable gift and estate taxes, and it's a great place for managing generational wealth. And that was one big reason why we chose from some considerations. Specifically talking about how it's related to either special purpose depository institutions or public trust companies and this type of situation. There's a couple of really specific points here. So when I talk about the types of entities in Wyoming that are related here, the two types are the SPDs, or the special purpose depository institutions, and public trust companies, which is what sFOX Safe is. So specific to both of those, you know, Wyoming has some specific pre-funding of receivership costs for SPDs in particular, and they also have, you know, dedicated statutory capital that public trust companies need to keep in reserve for dealing with these types of situations. You know, this is millions of dollars of capital that sFOX has put aside, and it's not operating capital. It's not to be used for anything. It's just purely held in, you know, essentially held in escrow for use in these types of situations to be sure that the company is well capitalized. Wyoming is also in their legislation, they have really focused in on clarity for digital assets, and a couple of the ways that they've done that are through use of the UCC, the Universal Commercial Code. So with the way that the UCC treats things, it's broadly applied in contracting and other business contexts as kind of the gold standard for use in these types of situations. And it clarifies a lot of distinctions across states to where you can just use the Uniform Commercial Code to sort things out. So a couple of those are, one is that the rights of creditors and debtors in bankruptcy and receivership are laid out in the UCC pretty clearly. So having a statutory mandate that Wyoming follows the UCC in particular cases really brings a lot of clarity. Also, from dealing with digital assets, you know, these are things that are a lot different from stocks and bonds and commodities and gold and a bunch of other assets that could be held in trust. So carving out that digital assets specifically are intangible property as opposed to currency or a commodity or security or other types of things really gives a lot of clarity that other states do not. Wyoming has taken a very considered approach to, you know, how these assets are valued, basically not treating them similar to the way other assets would be. They've considered, you know, how they can be used to satisfy debts, how they can be transferred, and a lot of these situations that really impact digital assets in these complicated situations. So yeah, generally, Wyoming has laid out a lot of these considerations through the legislation in the UCC. And yeah, for those reasons, we feel that Wyoming it has been a great choice for us, and how closely we've been able to partner with the Division of Banking and working through some nuances of our particular offering has been a great solution for us.
Awesome. Feeding off of those differences between different all the states, why did Wyoming choose banks instead of non-banks to service digital assets?
Yeah, Paige, there, in prior webinars, we've talked about some of the unique characteristics of banks in regards to being a fiduciary or a qualified custodian or some other similar considerations. Particular to this conversation, being a bank has certain benefits because in the U.S. bankruptcy code, certain banks cannot be depositors in certain types of bankruptcy proceedings, which is one thing that's nice to get simplified. A couple of the other ones are just that determining who owns the asset is, so there's really two main considerations here that banks are well suited for. One is who owns the asset, and the other is rehypothecation. The way that Wyoming has addressed both of these is for the who owns the asset consideration. A lot of people gloss over the fact that you can say something in a contract that can't be enforceable, right? One of the recent examples was Celsius, Celsius Network. In their bankruptcy proceeding, it was ruled that I think it was about $4 billion of client assets that were held were not client assets, that were Celsius's assets, and that could be used to satisfy creditor claims in the bankruptcy process. All right, so that's a really terrible result for the Celsius clients, who are now going to miss out on those assets being returned to them. Banking laws protect customers better than pure contract laws, right? And also from a statutory segregation perspective, right? You can say that you're going to segregate client assets, but a statutory view of things is going to be a lot harder to break than a pure contract basis, right? So that's the Celsius example. And for the second consideration, it's really about rehypothecation. So in the statutes, Wyoming explicitly allows certain things like buying and selling, staking, lending in particular situations, and it specifically disallows rehypothecation. Right? This is something very important for cases like this. And I actually did look it up, and in Prime Trust user agreement, they explicitly do allow rehypothecation of fiat in some circumstances, right? And that's one of those kind of red flag areas that if your qualified custodian is rehypothecating your assets, you should think twice about that. Specific to the Prime Trust situation, there are some things that are going to be difficult to figure out with the way that Nevada is going to sort through this. One is just who pays the legal bills of this process, right? I saw recently that the bankruptcy trustees in the FTX case have already accrued $120 million in legal and accounting fees in that. So there are not too many times when you can't incur $120 million in fees too many times before it starts to make a dent. So, and then with the types of clientele that Prime Trust has, I don't know the numbers, but they certainly have many IRA clients and maybe ERISA type plans that are involved. And will you be able to bail in those clients? For instance, if an IRA would have, they held an asset that was not lost, or that the keys were not lost to, will that client's assets be bailed in and reduced to make other clients, more whole on their holdings? These are some difficult questions that are going to have to be answered in the process, and that we feel Wyoming has done a really stellar job of addressing to avoid them.
Got it. John, you mentioned earlier that Prime Trust was granted their license in 2017 to operate as a trust company. Do Nevada trust companies undergo annual reviews? How was the situation just now uncovered?
Yeah. So this is definitely a very, very interesting one, right? And so I just said, right, yeah, they were granted their license in 2017. I do have to joke a little bit here. I know it's not a funny situation because this is a very, very serious situation, but they are a Las Vegas-based trust company. So it's a little bit of a gamble, I would say, if you're kind of putting your assets into a trust company that's based in Las Vegas. But in all seriousness, this, when I went back in and kind of looked through sort of some of the timelines of the cease and desist order, right? As you stated, right? So there was, the license was granted in 2017. The division, the Nevada FID, started in November of 2022, a safety and soundness examination. And so it's not clear, if the division conducted any other reviews prior to this, right? So you're thinking about this, they started in 2017, it's 2022, right? There's a number of years that have passed in between. From my research, I could not find anything, state examinations. Now, they do have to have independent, financial statement audits that would have needed to have been conducted. But to me, this is sort of like number one kind of red flag. And again, maybe this is just not publicly available information, but I haven't been able to ascertain whether there were any other sort of state, safety and soundness examinations prior to this one that commenced, in November of 2022. Right. The original exam, was the scope of the exam was, as of September 30th of 2022. However, at this particular point in time, the exam still remains open, right? So it's not, they haven't closed that exam. It's ongoing, and they've expanded the scope, and they need to obviously, review and monitor the solvency that's sort of expected here. A couple other things that really caused me some serious concerns, right, is, so back in March, so March 31st of 2023, the NMLS money service call report basically shows a negative equity of $12 million, right? And then, in June, right, we start to see Prime Trust unable to honor customer withdrawals. So there's a huge gap here when you talk about between March and June of March of a negative $12 million equity position, and still satisfying kind of customer withdrawals. Like you're not, it's not, this is kind of happening other than using client assets to kind of meet these demands. And so there's several kind of really big red flags that are sort of associated with this. I think, as the dust begins to settle, I think that there's going to be a lot of an examination of sort of, what exactly Prime Trust did and what they didn't do, and kind of how they got themselves sort of in this situation and how they kept digging a hole deeper and deeper. But I also believe that there's going to be some examination that's going to happen on the state side of things to really understand, what was going on here, where prior exams, like were there things that were missed that really should have been looked at, and a real sort of reevaluation of kind of, how the state does their examination process here, because there's some definite, key things that have been, just available in sort of the public domain around kind of key facts that cause to question really sort of, what was really sort of happening here from an examination perspective. So some really, really important things that I think still need to be reviewed and discovered in this space on both fronts, right? On what happens, with the Prime Trust side of things, but then also, on the state side of things, what, how does their review process actually, does that need to be sort of revamped, and were there things that were actually missed through this process? So.
Definitely. Court filings last week showed that Prime Trust owes customers more than 80 million in cash that it doesn't have. Some suspect that companies who migrated away from the custodian prior to the collapse may be subject to clawbacks. Can you explain what a clawback is and how it works, Daniel?
Sure, Paige, happy to. And yeah, the number that we're using here, 80 million, is a number that I've seen speculated and written that it could be closer to 150 million, because there's some quite illiquid altcoins here involved that might not be able to be liquidated for face value. So it could be a pretty substantial gap here. And the larger the gap, the more case there is that clawbacks should happen. I mean, generally, the concept of a clawback is just that previously allowed transfers to normal clients would be reversed under certain situations. One famous historical example of this is in the Bernie Madoff case. The owner of the Mets was an investor in Madoff's fund, and the funny thing about Ponzi schemes is that they're not actually bad for everybody, because if you're early, you end up getting a lot of money out, and then the later people get no money out. And the concept of the clawback helps to make it to where no one is detrimentally helped by someone else's loss, right? So in this case, the Mets owner had to pay back 160 million to the Madoff bankruptcy trustee. Between the concepts of bankruptcy and receivership, the clawback concept is treated a little bit differently. One reason for that is just the fact that there are many times more bankruptcies than there are companies in receivership. I don't know, it's a couple of orders of magnitude bigger and more common. So there are thousands and thousands of bankruptcy cases and case law that can be called upon. So it's fairly settled in those cases. The two types in bankruptcy are essentially preferential. So someone being preferentially treated, that could be an insider or someone with close ties to the firm, or fraudulent withdrawals. In a receivership, there is a more flexible standard. It's really just called improper payments, and there's less clarity around that. There's no set timeline, so that opens up the possibility that it could look back multiple years. And particularly in a case like this, where the situation came about, what was it, December of 21, John, when the keys were lost access to. So this is 18 months, maybe 2 years, when things get more progressed in the past. So it wouldn't be unreasonable for people to look back a significant amount of time to think about clawbacks. Related to the trust company component of this, as far as I can tell, this is really the case of kind of first impression for a sizable custodian in the crypto space. There have been plenty of bankruptcies in the crypto space, but not necessarily of a custodian or a qualified custodian. So and one other complicating factor here is just the fact that the keys, it would actually be easier if the money had been hacked, right? Because there would be someone you could go after around the world to try to recoup the money. But in this case, the keys were lost. So in theory, there's no one that can access the money, and no way that you can make up the deficiency. And just one more complicating factor in this clawback situation is the fact that the crypto markets are quite volatile, and the concept of fairness of equity in the courts is a real thing that you have to consider. And what's the more equitable thing to do? To claw back, say someone withdrew $1 million in Bitcoin back when Bitcoin was 70,000, and now that Bitcoin is worth less than half of that. And you're asked, they've used it to live on or to invest and do things with in their life, and to ask them to give back that full amount, that doesn't seem like an equitable solution either. So I think the unfortunate result is that there really are no winners here, and that everyone is going to come away hurt in some respect. unfortunately.
Yeah. Well, now we're on to the Q&A section. So we're starting to see a lot of great questions come in from the audience. If you're listening live, feel free to continue to send in your questions to the Q&A box and we'll get to them today. So for the first question, Prime Trust marketed that they were a qualified custodian. How do I know moving forward which custodians are actually safe to use?
John, I'll start here if you want to fill in anything afterwards. But the thing that comes to mind for me on this page is the concept of necessary and sufficient, right? So being a qualified custodian, I think, is necessary for you to seriously consider someone for your long-term storage, but it isn't necessarily sufficient, right? So that's step one. That's a qualifying thing that you can choose, but that really it doesn't give you enough information about your custodian's qualifications and their track record to really make a decision just based on that one fact. So there's a lot more that needs to go into your decision for choosing a custodian.
Yes.
Yeah, I mean, one thing I would actually also just sort of add here, right, is that the SEC continues to monitor and update their custody rules, right? And so if you take a step back for a second, right, kind of post 2008 sort of financial crisis and kind of after everything that sort of happened then, there was sort of a revamp of kind of, some of the custody rules in that space. And I think what we're seeing right now is potentially more kind of revamps of that in this space, right? Because again, we are talking about an asset class that historically doesn't sort of neatly fit into one of these buckets that the SEC has sort of looked at before in the past. Whether you agree or disagree, whatever, with the arguments around the SEC and digital assets are securities or not, I think there still is a lot of ambiguity, in this space around what it means for custody purposes, specifically from the SEC. And I think, this concept of a qualified custodian is a very, very hot topic that is, I think, very problematic. I think especially for the SEC when they look at custodians around kind of whether you ask about whether a custodian is a qualified custodian or not qualified custodian. I think one of the biggest things here that we have is just that the playbook is changing kind of as we speak, and so there still is a lot of ambiguity, uncertainty around kind of like this definition of the qualified custodian, under the sort of the SEC rules. But I think the concept of it still kind of applies to many other kind of custodians around, that we sort of see and explicitly kind of, in the that we look at. So.
Right. What does the future of crypto custody look like?
John, I'll start on this one. For me, this kind of dovetails very closely into what the future of trading looks like. And I think the answer to those two things are kind of inseparable, right? So in the past, the model was just, you have an exchange account with an exchange. That's where you custody because that's where you trade. And I think what we're going to see is more of a split and a separation of duties between those types of things in the future. And luckily, from a technological and a sophistication standpoint, those are becoming much more capable now than they have been in the past. So one way that could manifest from a trading perspective is just for accredited or ECP type clients is more flexible settlements, right? So you have your custodian and you also have trading counterparties, and you can trade and not have those amounts be pre-funded. So this is one flavor of this is post-trade settlement. We we offer that to our eligible clients, and it's a really great way to layer in security without really giving up access to the markets and the capital efficiency that you need. Another couple of more custody-centric approaches could just be either collaborative custody or tri-party agreements between multiple custodians in a sort of a multi-sig setup. So I think you will definitely see more of that happening in the future. The benefits of those types of situations are that, you know, a single, say it's a 2 of 3 or a 3 of 5 setup, you know, if one of the custodians has a catastrophic failure and loses access to your portion of the key, then, you know, some quorum of the remaining members could make up for that and not lose access to the keys. So I think we will see more of those things happening in the future. I'm personally skeptical of the proof of reserves and proof of liabilities models that I've seen so far. I don't think they're comprehensive enough to give you a good sense of their validity, and the way that there's a couple of ways that they can be gamed fairly easily, in my opinion. And also I think that just the old mantra of don't trust, verify has to always be top of mind and front of mind for people in the industry, because you know, it's at the end of the day, you have to be intelligent and thoughtful about how you're storing your assets. So
Very true.
I think, you know, kind of, you know, initially after sort of a post FTX world, we sort of saw this huge shift around kind of, you know, this move towards like self-custody kind of component, right? Because people just didn't obviously trust sort of exchanges on that front. And, you know, I think some people sort of very naively sort of thought like that was like the golden solution. And while that definitely is helpful in sort of certain situations, it's very, very challenging if you sort of are a high frequency trader. It doesn't sort of solve like any of these problems around, you know, loss of access, you know, to your wallet or anything along those lines. So I think having a robust custodian in this place is really sort of, you know, the benefits of that. And I think, you know, Daniel kind of touched on this piece though, is just like, you really need to kind of do your homework and really sort of understand, you know, how your custodian is operating, what are the controls that they have in place, how are they protecting your assets, and in the event of kind of a bankruptcy or sort of something that we're sort of seeing like in the prime trust space, how can you be assured that your assets are protected and segregated away from the firm assets? And, you know, time and time again, now we've seen multiple sort of situations where this commingling of assets has caused a tremendous amount of issues and problems for clients, right? And so it's really, really important that clients clearly understand that how their custodian is clearly segregating and separating their assets away from firm assets. It's kind of just basic, you know, client assets sort of 101, but it is really, really imperative in the digital asset space.
Right. Coinbit said Prime Trust still has enough Bitcoin to honor our members' balances and plans to move towards a no custody solution in the future. What are your thoughts on a no custody solution?
yeah, it's a little bit of a confusing sentence, because the not to be impolite about it, but the prime trust situation right now is a no custody solution. Nobody has access to the keys, and you don't want a no custody solution. You know, you might want a multi-sig solution or a collaborative custody solution where no single party can unilaterally move funds, or no one person's single mistake can be catastrophic enough to where you don't have access to the funds. But yeah, as far as I know, you do not want to get into a no custody solution, because that would be a problem. And just as another mantra from the cypherpunks, don't roll your own crypto, right? A lot of these sayings are funny because they didn't come up with that for no reason, right? They came up with it because a bunch of people, this is even before Bitcoin came around, like you would encrypt your hard drive or encrypt your computer or your email or something, and you'd come up with some complicated system of how to do it that only you know how to do, and you'd forget the system. And now your computer is locked and you've just got to throw away that laptop, right? So, don't roll your own crypto. It doesn't exist for no reason. And that's why, companies like sFOX exist, is to make it to where you don't have to roll your own crypto, and you can work with someone who's been doing it for years.
I like that. I'm going to keep that saying going forward. So as we come to the end of the webinar, I have one final question for each of you. John, as we continue to learn about this situation and move forward with regulation, what should a trader or a client be focused on when choosing a custodian?
So there's a couple things that I would basically just sort of say, in this on this front, and there's a few kind of basic things, but one of the things I would look at is where is that custodian, right? All jokes aside, right? There are different states that have sort of different, trust company licenses that allow for sort of custodial activities. In my opinion, right, like Wyoming is by far and away sort of the front runner in this space. And it's a very specific reason. And kind of Daniel outlined a few of those kind of key components of why we chose to kind of create our trust company in Wyoming. I really, really feel that like they are the industry leader in this space, and really have their pulse on kind of what's happening in the industry, and is very, very focused on digital assets and the custody of digital assets. I feel like sort of some of the other states have kind of taken their trust company licenses and sort of shoehorned it a bit into trying to make it fit for digital assets, where I think Wyoming has really, really done something different there to kind of really cater their offering specifically for the digital asset community. So that's number one. And then, I did touch on this before, right? I really feel like, it's important that, clients do a little bit of the homework on this front. A lot of the information that, we're able to find here and talk about today is all publicly available information. And so I think it's really, really important that you understand where your crypto is being custodied, how it's being custodied, how it's being protected, right? Those are the three things that really everyone should be doing as far as due diligence when looking to try and figure out where and who they should custody their crypto with.
Right. Daniel, how does sFOX handle new clients looking to transition out of Prime Trust and over to a new custodian?
Sure, Paige. Yeah, I mean, this is, I know we've had a good time today, but this is a very serious situation with, millions and tens of millions of dollars at issue here. So first of all, we are here to talk. We have, many members on our team who are talking to clients every day about these types of conversations. And we are more than happy to take as much time as needed and to understand, helping our clients or prospective clients understand, what's happened with their accounts on other platforms, the ways that they should think about possibly transitioning to sFOX Safe, and just our product generally. And myself, John, and all the other people on the team are essentially an open book to having any discussion that we need to with clients about these types of issues, because they're very serious and we take it very seriously as well. One of the good things about our product is just the flexibility that it has for meeting client needs, right? So if you already have a custodian that you're working with that you're happy with, you know, we're not going to push you to come away from that. All right. You can still trade with us, and we can get you set up on a flexible settlement program that can help you keep your custody, keep your processes in place, but also layer in a better trading experience. We have clients that do everything with us, you know, through a full, you know, Prime Trust style API driven integration through our sFOX Connect product, which we've been seeing a lot of clients come to. So our product is really flexible enough to meet most any client need. And given that, it's really good for everyone to always understand the trade-offs that are inherent in any solution, because you know, Bitcoin and crypto are complicated enough as it is. And you don't really need someone overselling you on their solution, right? If someone tries to sell you a solution that doesn't have any trade-offs, you should probably be concerned about that, because you know, this is the industry for professionals and people with, you know, security mindset and compliance mindset and taking it slow. You know, not for the people who are rushing to be first out the door just to make a splash in the market, right? And I think we've done a great job of keeping that type of mindset through the ups and downs. The kind of the last thing I'd love to pass on to people that are looking to transition their custody in particular is we have some fantastic summer specials going on right now with discounts of 50% for your first year of custody if you're transitioning from any other custodian to sFOX. So I would really encourage you to reach out to myself or anyone else on our team and have a conversation about that, because we're seeing a lot of people taking us up, and we love to see it.
Great. Well, that concludes our webinar for today. So thank you to our panelists, John and Daniel. This has been very informative. Also, thank you to everyone who attended. We hope you learned something new, not only about the Prime Trust situation, but also about sFOX. Stay tuned for next month's webinar and keep an eye on your inbox for an email with the recording from today. And if you have any follow-up questions that we didn't get to, please reach out to our sFOX team directly, and we'll be more than happy to help you. Thank you and have a great day.
Thanks, Paige.
Thanks,
Thanks, Tom.
Thanks, Paige. Thanks, Sam.